So you're building a business here in the Philippines. You've got a small, tight-knit team, and you've probably asked yourself, how do we get the legal protection of a huge company without all the stuffy, rigid rules? Well, today we are diving into a powerful but often overlooked solution, the closed corporation. Every startup hits this classic dilemma. Do you go for that ironclad liability shield a corporation gives you? Or do you want the flexibility and trust you get with a partnership? It always feels like you have to pick one. But what if you didn't have to? What if you could actually have both? Well, it turns out Philippine law has this special vehicle designed to solve this exact problem. It's called a closed corporation. Think of it as a hybrid, something that tries to give founders the best of both worlds. But, and this is important, only if you follow the rules very, very carefully. So how do you make it official? How do you become a closed corporation? It's not about the vibe of your company. It's about what's written in its legal birth certificate, the Articles of Incorporation. You have to spell out 3 specific rules, and a good way to remember them is the LRP test. First, L is for limit. You cannot have more than 20 stockholders. Simple enough. Second, R is for restriction. Every single share has to have limits on who it can be sold or transferred to. And third, P is for public offering. You are legally forbidden from ever listing your company on a stock exchange. You have to get all 3 of those in writing in your official papers. Do that, and you're in.
Now hold on, because this powerful structure isn't for just anyone. The law is very specific about who can't form a closed corporation. Generally, it's industries that are seen as having a big public interest. So if your business is in mining, oil, banking, insurance, public utilities, or even education, sorry, you'll have to stick with being a regular corporation.
And this brings us to a really critical point, a quote from the Philippine Supreme Court that gets right to the heart of this whole thing. They said that being a closed corporation is a statutory status, not a factual one. Now, that might sound like just legal jargon, but trust me, it's a lesson that came out of a very real and probably very expensive court case. Let's look at that case, San Juan Structural. You had a husband and wife who owned 99.8% of their company. I mean, it doesn't get much more close than that, right? So one of them sells some company land without a formal board meeting. The person who bought the land argued, hey, it's basically a closed corporation, so the sale should be fine. But the Supreme Court said, nope. Because those 3 golden rules, the LRP test, weren't written in the company's official papers, it was just an ordinary corporation, no matter who owned the stock. The lesson here is crystal clear. What's on paper is what truly counts. Okay, so you've done your homework, you followed the rules, you put the magic words into your articles of incorporation. Now what? What do you actually get for all of that trouble? Well, this is where the special powers kick in, and they can fundamentally change the rules of the road for how you run your business. One of the biggest advantages is being able to control exactly who your business partners are. To make sure a restriction on selling shares is legally bulletproof, like, say, giving existing partners the first right to buy, the law says you have to state it clearly in 3 different places. I like to call it the ABC rule. It has to be in the Articles of Incorporation, in the bylaws, and it has to be printed right there on the certificate of stock itself. Miss just one of those, and the next thing you know, your co-founder's disgruntled cousin could be sitting at the boardroom table. Now for what I think is a true founder superpower, preemptive rights. In a regular, everyday corporation, your right to buy new shares to keep your ownership percentage from getting diluted, that usually only applies when new stock is issued for cash. But in a closed corporation, that right is way stronger. It extends to all stock issuances, even treasury shares that the company bought back. It's a much, much tougher shield to protect your stake in the company you built. And this is where we get that partnership vibe we talked about earlier. You can literally write into your articles of incorporation that the business will be managed directly by the stockholders. You can completely bypass the need for a formal board of directors. This allows for way faster, more informal decisions. But, and it's a huge but, there's a trade-off. The law says that if you do this, those stockholders are now legally considered directors, which means they also take on all the legal liabilities that come with being a director. Which, of course, leads us to the biggest fear for any entrepreneur. By choosing this flexible structure, are you giving up that corporate shield? Are you putting your personal assets, your house, your savings, on the line for the business's debts? Let's just ask the question straight up, because every founder needs a crystal clear answer to this. Are the owners of a closed corporation personally on the hook for what the company owes? And the answer, thankfully, is generally no. That fundamental protection of the corporate shield,
It still holds, but you really need to understand the exceptions.
So, the general rule is limited liability. Your personal assets are safe. But there are two really critical exceptions. First, remember how you can manage the company directly? Well, if you do, you are personally liable for your managerial acts. Second, if you actively participate in a corporate tort, which is a legal way of saying the company did something wrong, like commit fraud and you were involved, then yeah, you can be held personally liable for the damages. And hey, don't just take my word for it. The Supreme Court has confirmed this. In a case called Bustos v. MSI, the court was super clear. Just because you're a closed corporation, that does not automatically make you a personal guarantor for every single company debt. The corporate shield is still very much there, unless one of those specific exceptions comes into play. Okay, so your personal assets are mostly protected. That's great. But what protects the business from the founders themselves? Let's talk about another all too common problem. The business is going, but the founders are totally stuck. The very partners who built this thing together now can't agree on anything. What happens then? The law actually has a specific term for this exact situation: deadlock. It's when the owners are so divided that the company is paralyzed. You can't get enough votes to make a decision, and the business just can't move forward. In a regular corporation, this can be an absolute disaster. But in a closed corporation, you have a really powerful option. You can go straight to the Securities and Exchange Commission. And the SEC has a special toolkit to break that deadlock. You can remember it as PAD. First, they can appoint a provisional neutral director to come in and act as a tiebreaker. Second, they can order you to alter the company's articles or bylaws. And finally, as a last resort, they can order the dissolution of the corporation. And this might be the most powerful feature of them all. I like to call it the ultimate escape hatch. Under Section 104, any stockholder in a closed corporation can force the company to buy back their shares at a fair value for any reason at all. You don't need a huge fight. You don't have to prove you are wronged. If you just want out, you have a legal right to demand a buyout, as long as the company has the money to do it. So when you look at the whole picture, the strict rules you need to follow to get in, the incredible flexibility you get in management, the strong protections against your ownership stake getting watered down, and these powerful escape hatches for when things go wrong, it all boils down to one final question. Is the closed corporation a uniquely powerful tool designed for savvy founders? Or is it a legal trap, just waiting for those who aren't prepared for its unique rules and liabilities? Well, the answer, as with most things, depends on knowing the rules of the game.